contract. The movement of the progressive society has hitherto been a movement from status to contract. Contracts are the basis of many of our daily activities. They provide the means for individuals and businesses to sell and or otherwise transfer property, services, and other rights. The purchase of goods such as books and automobiles, notice how they didn't say motor vehicle, automobiles, is based on sale contracts. The hiring of employees is based on service contracts. The lease of an apartment is based on rental contracts. The list is almost endless. Without enforceable contracts, commerce would collapse. Contracts must not be contracts must not be the sports of an idle hour, mere matters of pleasantry and badinage, never intended by the parties to have any serious effect whatever. Contracts are voluntarily entered into by parties. The terms of the contract become private law between the parties. So, contract creates the law, equity follows the law. One court has stated that the contract between parties is the law between them, and the courts are obliged to give legal effect to such contracts according to the true interest of the parties. In other words, Article 1, Section 10 of the United States Constitution clearly states that the government cannot impede the obligation of contract. All right? Nevertheless, most contracts are performed without the aid of the court system. This is usually because the parties feel a moral duty to perform as promised, although some contracts, such as illegal contracts, are not enforceable. Most are legally enforceable. This means that if a party fails to perform a contract, the other party may call upon the courts to enforce the contract. Such topics of the definitions of a contract, requirements for forming a contract, sources of contract law, and the various classifications of contracts are as follows. Definition of a contract. A contract is an agreement that is enforceable by a court of law or equity. A simple and widely recognized definition of contract is provided by the restatement section of contracts. A contract is a promise or a set of promises for the breach of which the law gives a remedy or the performance of which the law is some way recognized a duty. Parties to a contract. Every contract involves at least two parties. The offerer, which is the debtor, is the party who makes an offer to enter into a contract. The offeree is the party to whom the offer is made. The offeree would be the creditor. In making an offer, the offeror promises to do or to refrain from doing something. The offeree then has the power to create a contract by accepting the offerer's offer. A contract is created if the offer is accepted. No contract is created if the offer is not accepted. Let me go into a little deeper explanation of this. The one making the offer or advertising is the debtor. They need something from you, making you the creditor. If you are the one receiving the offer and accepting the offer, because you're the creditor, you get to stipulate the terms and the conditions. This is so vitally important for everybody to comprehend. So there are so many posers out there calling themselves creditors that don't have a fucking clue about what they're saying. And I'm talking about people that work at retail outlets. I'm talking about automotive dealerships where they're telling you they's a creditor. They're full of shit. Okay? They're the debtors making the offer. That's why it's so imperative that you slow down and read the contracts and red line veto shit just like Nixon did. If you don't like what the offer states, because you're the one accepting the offer, making you the creditor, you get to stipulate the terms and fucking conditions. Period. End of story. If you don't want to give away your rights, titles, interests, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, chattel security, trust residuals, rents, profits, proceeds, futures, and annuities, you are not forced to. That is a voluntary act, ladies and gentlemen. Again, if they're the offerer, they're the debtor. They need something from you. If they are advertising, they are a debtor. They need something from you. If you're the creditor and you're accepting the offer, you get to stipulate the terms and conditions. All right? Can't be any more clear than that. Stop acting like raccoons and grabbing shiny shit and running off thinking like that you got a sweet deal when you took a fat cat in the ass, because that's exactly what happened. It's exactly what happened when you didn't slow down and read the terms and conditions of the contract that you voluntarily entered into. In most instances, it says, I acknowledge and have read the entirety of this contract, a retail installment agreement or security agreement, and I heretofore agree with the following terms and conditions, or the aforementioned terms and conditions. You've got to read, ladies and gentlemen. Reading is fundamental. It should be fun for you to read. It should be fun mentally for you to read these contracts that you're entering into. So many people get a hold of me crying after the fact. Seeking counsel after the deed is done is always in vain. All right? Seek counsel prior to entering into that contract. Take yourself 72 hours to sit back and read it. Understand it. If you don't understand it, it's not written in plain English. Get some clarification or red line veto that shit. Chances are, if you don't understand it, it wasn't written in your favor. Elements of a contract. To be an enforceable contract, the following 4 basic requirements must be met. Not might be, not shall be, must be met. Number 1, agreement. To have an enforceable contract, there must be an agreement between the parties. This requires an offer by the offerer, the debtor, and an acceptance by the creditor, the offeree, of the offer by the offeree. There must be mutual assent by the parties. It must be mutually beneficial for all parties involved. It must be written in plain language. There must not be any blind, hidden adhesion contracts. Okay? Pay attention. I'm speaking with great clarity this evening for you, ladies and gentlemen out there. Number 2, remember, these are the 4 elements that must be in a contract in order for it to be a binding contract. Number 2, consideration. The promise must be supported by a bargained for consideration that is legally sufficient. Gift promise and moral obligations are often not considered supported by valid consideration. Number 3, contractual capacity. The parties to a contract must have contractual capacity. Certain parties, such as persons adjudged insane, do not have contractual capacity. If you're under the influence of drugs and alcohol, ladies and gentlemen, you cannot legally enter into a contract. You are of unsound mind. You are not capable of entering into a legally binding contract. For those of you that are elders and you're going and get new forms of medication at the doctor, and you decide on a whim after going to see a doctor and trying a new fucking pill that you're going to go buy a car, you have a plausible defense predicated on the fact that you're on new medication and you were not of sane, sound mind at the time. I've helped a guy reverse a sale of his property. He was on new medication. He sold his property for way under its value, and we were able to reverse that contract because he was under new medication from a doctor. Okay. Number 4, Lawful object. The object of the contract must be lawful. Contracts to accomplish illegal objects or contracts that are against public policy are void. Not voidable, flat out motherfucking void. All right, void in abnitio, non pro tunc. So again, let's go through it real quick. There are 4 elements that must be, not shall be, not might be, must. 1 is the agreement. 2 is consideration. 3 is contractual capacity. So are you of majority age, of sane, sound mind, competent to handle your own affairs as a man or woman? Yes or no? Are you under the influence of drugs and alcohol? Has your mind been altered in any way, shape, or form? Have you been recently diagnosed with leukemia or something like that? It is clouding your judgment, okay? For people in that state of mind, I would highly advise that you do not enter into contracts. Number 4, lawful object, meaning that if any part of the contract is illegal, the whole fucking contract is void, okay? You can't cherry pick the good out of a contract and say, okay, well, we'll just forget about the illegal shit, the illicit shit, the bad stuff in the contract, and we'll say that everything that's lawful in the contract still stands. That's bullshit. All right? So the contract must be lawful, must be mutually beneficial for all parties involved, must have value and consideration given. Defense to the enforcement of a contract. There are 2 defenses that may be raised to the enforcement of contracts. These defenses are as follows. Genuineness of assent. The consent of the parties to create a contract must be genuine. Genuineness of assent. The consent of the parties to create the contract must be genuine. If the consent is obtained by duress, undue influence, or fraud, there is no real consent. Remember, if there's any hidden contracts, blind adhesion contracts, things that were left out or not mentioned, the contract is void in ab initio. Writing and form. The law requires that certain contracts be in writing or in a certain form. Failure of these contracts to be in writing or to be in a proper form may be raised against the enforcement of the contract. In all state statutes, and every state varies, so you have to go look. But for example, in Nebraska, any contract that exceeds $500 in value must be in written form. Any contract that exceeds a certain duration of time must be in written form. Okay, so I would highly advise that everybody do their contracts in written form. Words so often dissipate in the wind. Put it down on stone. It's less likely to blow away. All right? Put it in writing. Have 2 witnesses bear witness to the adjoining parties' signatures to the contract. Remember, the good Lord tells us that where there are 2 or more witnesses, we can have resolve. All right? So you always want to have witnesses. If nobody's witnessing the signatures of the contracts, the signatures on the contracts can be contested. I always like wedding signatures. I don't like this digital age bullshit. It's too easy to counterfeit people's signatures on shit. And in a day and age where nobody reads a fucking thing they're signing, it's scary to have a digital signature out there. Because they can pop your digital signature on anything and say, you signed it, did you read it? Well, no, I really didn't read it. Well, Your Honor, they admit they didn't read it, and they're not contesting the fact that they signed it, so they agree they signed this, and they agreed to give us their house and their firstborn kid, and Johnny over there agreed to give us his left testicle, and Martha's going to be baking us pies for the next year, free of charge. They all agreed to it. See, this is their signatures. So again, slow down. The other thing I would highly advise is that everybody get certified copies of the contract and you record them on public record at the county recorder's office. Now you have a public record of your private contract that is admissible in court, and you can obtain certified copies from the county recorder's office. Source of contract law. There are several sources of contract law in the United States, including the Common Law of Contracts, the Uniform Commercial Code, and the restatement, second, of contracts. The following paragraphs explain these sources in more detail. Common law of contracts, contract law developed primarily by state courts. A majority source of contract law is the common law contracts. The common law of contracts developed from early court decisions that became precedent for later decisions. There is a limited federal common law of contracts that applies to contracts made by the federal government. The larger and more prevalent body of common law has been developed from state court decisions. Thus, while the general principle remain the same throughout the country, there is some variation from state to state. The Uniform Commercial Code, comprehensive statutory scheme that includes laws that cover aspects of commercial transactions. Another major source of contract law is the Uniform Commercial Code, otherwise identified as the UCC. The UCC, which was first drafted by the National Conference of Commissioners on Uniform State Law in 1952, has been amended several times. Its goal is to create a uniform system of commercial law among the 50 states. The provisions of the UCC normally take precedence over the common law of contracts. The UCC is divided into 9 main articles. Every state has adopted at least part of the UCC, or Uniform Commercial Code. The restatement of the law of contracts. In 1932, the American Law Institute completed the restatement of the law of contracts. The restatement is a compilation of contract law principles as agreed upon by the drafters. The restatement, which is currently in its second edition, will be cited in this book as Restatement Second of Contracts. Note that restatement is not law. However, lawyers and judges often refer to it for guidance in contract dispute because of its stature. Restatement of Law Contracts, a compilation of model contract law principles drafted by legal scholars. The restatements is not law. Classification of contracts. There are several types of contracts, each different somewhat in information, enforcement, performance, and discharge. The different types of contracts are discussed in the following paragraphs. Bilateral and unilateral contracts. Contracts are either bilateral or unilateral, depending upon what the offeree must do to accept the offerer's offer. The contract is bilateral if the offerer's promise is answered with the offeree's promise of acceptance. In other words, a bilateral contract is a promise for a promise. This exchange of promise creates an enforceable contract. No act of performance is necessary to create a bilateral contract. Bilateral contract. A contract entered into by way of exchange of promises of the parties. A promise for a promise. Unilateral contract. A contract in which the offerer or offeror's offer can be accepted only by the performance of an act by the offeree, a promise for an act. A contract is a unilateral if the offerer's offer can be accepted only by the performance of an act by the offeree. There is no contract until the offeree performs the requested act. An offer to create a unilateral contract cannot be accepted by a promise to perform. It is a promise for an act. The language of the offerer's promise must be carefully scrutinized to determine whether it is an offer to create a bilateral or a unilateral contract. If there is any ambiguity as to which it is presumed to be a bilateral contract. Consider the following examples. Suppose Mary Douglas, the owner of the chick dress shop, says to Peter Jones, a painter, "If you promise to paint my store by July 1st, I will pay you $2,000. Peter promises to do so. A bilateral contract was created at the moment Peter promised to paint the dress shop. A promise for a promise. If Peter fails to paint the store, he can be sued for whatever damages result from his breach of contract. Similarly, Peter can sue Mary if she refuses to pay him after he has performed as promised. However, if Mary had said, "If you paint my shop by July 1st, I will pay you $2,000, the offer would have created a unilateral contract. The offer can be accepted only by the painter's performance of the requested act. If Peter does not paint the shop by July 1st, there has been no acceptance and the painter cannot be sued for damages." Incomplete or partial performance. Problems can arise if the offerer of a unilateral contract attempts to revoke an offer after the offeree has begun performance. Generally, an offer to create a unilateral contract can be revoked by the offerer anytime prior to the offeree's performance of the requested act. However, the offer cannot be revoked if the offeree has begun or has substantially completed performance. Suppose Alan Matthews tells Shirley Levon that he will pay her $5,000 if she finishes the Boston Marathon. Alan cannot revoke the offer once Shirley starts running the marathon. Express and implied in fact contracts. An actual, as distinguished from a quasi-contract, which is discussed later in this chapter, may be either express or implied in fact. Express contracts are stated in oral or written words. Examples of such contracts include an oral agreement to purchase a neighbor's bicycle and a written agreement to buy an automobile from a dealership. Implied in fact contracts are implied from the conduct of the parties. Implied in fact contracts leave more room for questions. Requirements for an implied in fact contract. The following elements must be established to create an implied in fact contract. Number 1, the plaintiff provide property or services to the defendant. Number 2, the plaintiff expected to be paid by the defendant for the property or services and did not provide the property or services gratuitously. Okay, number 3, the defendant was given an opportunity to reject the property or services provided by the plaintiff but failed to do so. Express contract, an agreement that is expressed in written or oral words. Implied in fact contract, a contract where agreement between parties has been inferred from their conduct. Formal and informal contracts. Formal contract, a contract that requires a special form or method of creation. Formal contracts. Contracts may be classified as either formal or informal. Formal contracts are contracts that require a special form or method of creation. The Restatement Second of Contracts identifies the following types of formal contracts. Number 1, contracts under seal. This type of contract is one to which a seal, usually a wax seal, is attached. While no state currently requires contracts to be under seal, a few states provide that no consideration is necessary if a contract is made under seal. Number 2, recognizance. In a recognizance, a party acknowledges in court that he or she will pay a specified sum of money if a certain event occurs. A bail bond is an example of a recognizance. Number 3, negotiable instruments. Negotiable instruments, which include checks, drafts, notes, and certificates of deposit, are special forms of contracts recognized by the UCC. They require a special form and language for their creation and must meet certain requirements for their transfer. Number 4, letters of credit. A letter of credit is an agreement by the issuer of the letter to pay a sum of money upon the receipt of an invoice and bill of lading. Letters of credit are governed by the Uniform Commercial Code. Informal contract. A contract that is not formal, valid, informal contracts, that is not formal. Valid informal contracts are fully enforceable and may be sued upon if breached. Informal contracts. All contracts that do not qualify as formal contracts are called informal contracts or simple contracts. The term is a misnomer. Valid informal contracts, ergo leases, sales contracts, service contracts, are fully enforceable and may be sued upon if breached. They are called informal contracts only because no special form or method is required for their creation. Executed contract. A contract that has been fully performed on both sides, a completed contract. Executed and executory contracts. A completed contract that is one that has been fully performed on both sides is called an executed contract. A contract that has not been performed by both sides is called an executory contract. Contracts that have been fully performed by one side but not by the other are classified as executory contracts. Executory contracts. Consider these examples. Suppose Elizabeth Andrews signs a contract to purchase a new Jaguar automobile from Ace Motors. She has not yet paid for the car, and Ace Motors has not yet delivered it. This is an executory contract. 2. Assume that the car was paid for, but Ace Motors has not yet delivered the car. Here, the contract is executed by Elizabeth, but is executory as to Ace Motors. This is an executory contract. 3. Assume that Ace Motors now delivers the car to Elizabeth. The contract has been fully performed by both parties. It is an executed contract. Valid, void, voidable, and unenforceable contracts. Valid contract. A contract that meets all of the essential elements to establish a contract. A contract that is enforceable by at least one of the parties. A valid contract is one that meets all of the essential elements to establish a contract. In other words, it must, not shall, not might, not may, it must consist of number 1, consist of an agreement between the parties. Number 2, be supported by legally sufficient consideration. Number 3, be between parties with contractual capacity. And number 4, accomplish a lawful objective. Valid contracts are enforceable by at least one of the parties. A void contract. Void contract, a contract that has no legal effect, a nullity. A void contract is one that has no legal effect. It is as if no contract had ever been created. For example, a contract to commit a crime is void. If a contract is void, neither party is obligated to perform, and neither party can enforce the contract. A voidable contract. Voidable contract. A contract where one or both parties have the option to avoid their contractual obligations. If a contract is avoided, both parties are released from their contractual obligations. Avoidable contract is one where at least one party has the option to avoid his or her contractual obligations. If the contract is avoided, both parties are released from their obligations under the contract. If the party with the option chooses to ratify the contract, both parties must fully perform their obligations. With certain exceptions, contracts may be voided by minors, insane persons, intoxicated persons, persons acting under duress, undue influence, or fraud, and cases involving mutual mistake. An unenforceable contract. A contract where the essential element to create a valid contract are met, but there is some legal defense to the enforcement of the contract. An unenforceable contract is one where there is some legal defense to the enforcement of the contract. For example, if a contract is required to be in writing under the statutes of fraud, but is not, the contract is unenforceable. The parties may voluntarily perform a contract that is unenforceable. Quasi-contract, implied in law contracts. or implied in law contracts, an equitable doctrine whereby a court may award monetary damages to a plaintiff for providing work or services to a defendant, even though no actual contract existed. The doctrine is intended to prevent unjust enrichment and unjust detriment. The equitable doctrine of quasi-contract, also called implied in law contract, provides that the court may award monetary damages to a plaintiff for providing work or services to a defendant, even though no actual contract existed between the parties. This doctrine, which is intended to prevent unjust enrichment and unjust detriment, does not apply where there is an enforceable contract between the parties. In addition, recovery is generally based on reasonable value of the service received by the defendant. A quasi-contract is imposed where, number one person confers a benefit on another who retains the benefit, and two, it would be unjust not to require that person to pay for the benefit received. Consider this example. After an automobile accident, a person is rendered unconscious and injured alongside the highway. If a medical doctor stops and renders aid that saves the person, that person owes the medical doctor the reasonable value for the services rendered. The medical doctor can recover this amount under the doctrine of quasi-contract. Equity and the law of contracts. Equity, a doctrine that permits judges to make decisions based on fairness, equality, moral rights, and natural law. Recall the two separate courts developed in England, a court of law and a chancery court, or courts of equity. The equity court developed a set of maxims based on fairness, equality, moral rights, and natural law that were applied in settling disputes. Equity was resorted to when 1. An award of money damages at law would not be the proper remedy, or 2. Fairness required the application of equitable principles. Today, in most states of the United States, the courts of law and equity have been merged into one court. In an action in equity, the judge decides the equitable issue. There is no right to a jury trial in an equitable action. The doctrine of equity is sometimes applied in contract cases. When we come back, we'll be talking about agreements.